In an earlier Mindful Live session where we were talking about crime and criminality in Trinidad and Tobago, I was making the point that I regularly make that to me, when you're looking at crime, criminality, things happening negatively in terms of law enforcement to the citizens of a country, the blame would obviously start at the police. Obviously, because they are the ones that are supposed to be in between the lawbreakers and the lawkeepers. Yes, there are social issues causing the lawbreakers to be as they are. Granted, there are social ills and all of that. Yes, true. But nonetheless, the police are hired regardless of the social ills, to be able to find a solution to some of these people that are bringing about some of those social ills too. But an officer inside of the live was highlighting a point. An officer speaking in live was highlighting the point that very often the police in Trinidad and Tobago, they do go out there and collect the criminals, capture them, charge them with something, and when they enter the judicial system, it's a clown show inside of our judicial system. They're released quickly on bail, and even for the case to actually be completed, very often it's over a decade, over 13, 14, 15 years, and some of these cases are not completed. So the analogy I was making, I believe in the video yesterday that I was talking about crime, imagine a plant, a tree that is a crime tree growing in Trinidad and Tobago. We have a crime tree that is growing very healthily in this country, and criminality is the fruit that comes from this crime tree, and this criminality fruit falls onto the soil of Trinidad and Tobago. It poisons our soil. That's the analogy I had. And the police job is to collect this fruit before it drops into the soil so that it does not poison the soil of this country. The police are saying that sometimes they go out there and they're collecting the fruit. They're picking up the fruit. They're doing their fruit catching duties. But when they carry the fruit, their job isn't to hold the fruit. They carry the fruit to the basket for the basket to do whatever they have to do with the fruit and get rid of it. And this judicial basket is releasing all the fruits and throwing them back onto the land to poison our country again. So in that case, it's not just on the police. And granted, let it be known that when I speak about this, I know it's obviously not one person you point at. I'm talking about where you'd start the blame. That's not necessarily where it would end, but it is where it would start. But where the blame continues, the next part of it in our criminal justice system, right past the police, which granted they do have the corruption issues and etc., the step after them, I don't think is any better than the Trinidad and Tobago Police Service. In fact, it might be worse. So we're going to get into some stories that highlight some of that. Before we do that, make sure you hit that like button. Take a pause. Yes. Do it. Yes. Nice. Good. If you're looking at this, make sure you hit that like button. It really does help. Drop a comment if you have something to say. It helps boost the algorithm. And if you are not subscribed, now would be a good time to be subscribed. There are other videos coming very soon. We're looking to drop videos pretty regularly on this channel. Now, $20 million scandal mix up in serving documents in Naipaul Coolman case. I don't know how many of you might remember, but not that long ago, they talk about Trinidad and Tobago having a very short memory. We have political amnesia. Well, not too long ago, some men who were accused of kidnapping a well-known businesswoman and murdering her in Trinidad and Tobago a couple of years ago, a good few years ago, some men who were accused of that were freed of the charges and turned around and sued the state using a former attorney general to do that lawsuit, just by the way, and eventually winning the lawsuit, winning some $20 million because the state didn't even mount a defense. The ruling was in default, so the state didn't even mount a defense. The men were given that they were awarded that $20 million. Then when the state found out, oh no, it made the news, the $20 million, then they rushed in to try and rectify issues. What they said was the document that was filed to show the state, to tell the state that they are being served in this case, the document disappeared. Strange. But the Attorney General said that he's going to launch an investigation. So he launched that investigation, and what would you know? The document reappeared. And I read last week, sometime last week, the investigation was completed and handed over to the Attorney General. And these things don't make the same amount of news as the initial story. So I guess the real conclusion of that investigation, as in the words inside of that investigative document, we may never know, but It's a mix-up, according to those that were in the know in this thing. A mix-up in serving documents. This is the explanation given by the Office of the Attorney General for the outcome of a $20 million malicious prosecution lawsuit. The suggestion that the court filings in the case were served on the wrong department of the Ministry of the Attorney General and Legal Affairs was made by the legal director of the Attorney General's Secretariat, Trini Ramkisoon, in a recent application filed to set aside the default judgment that was obtained by the men and the corresponding $20 million compensation for them that was assessed by the High Court Master Martha Alexander on June 30th. In the court filings obtained by Guardian Media, Ramkisoon claimed that after the case was filed by the group's legal team, led by senior counsel Anand Ram Logan of Freedom Law Chambers on May 29, 2020, it was served on State Counsel 111 Natoya Moore at the Office of the Solicitor General almost a month later. She claimed that after no appearance or defense was entered by the state, the group's legal team applied for the default judgment before Justice Joan Charles on August 5th, 2020. The application was served on Acting Court Clerk 1 Sarah Chinwasa at the Chief State Solicitor's Department on November 12th, 2020. On the same date, the court office issued a notice of hearing to the Solicitor General. However, the notice was served on Acting Court Clerk 1 Shanice Paris at the Chief State Solicitor's Department almost a week later. The AG's office was not represented at the hearing before Justice Charles, who granted the default judgment to the group on January 8, 2021. In the application, Ramkisoon suggested that the default judgment should be set aside as it was irregular and wrongly entered because it was improperly served on the Chief State Solicitor's Department. She pointed to Section 21 of the State Liability and Proceedings Act, which states the litigation against the state should be served on the AG's office through the Solicitor General or personnel that are designated through a notice in the Gazette. There is no provision in law for service of documents in civil proceedings to be effected on the Chief State Solicitor's Department or employees of this department. There was no attorney on record from the Chief State Solicitor's Department who could accept service of documents in this matter, Ramkisoon said. Now, I find something a bit strange about this because the complaint she's making here is basically that the people who were served the legal documents, they were not the legal representatives allowed to be served those legal documents. I could understand, like, okay, in law, in legality, there are particulars where, you're supposed to serve this specific person. It's supposed to be done to this person, to that person, to the other. But if we're thinking about this realistically, and you're serving something on a government office, you go to the government office, very likely it's a clerk who might come out and you can give them that and expect that it will be run up the chain. Are you telling me that the Chief Solicitor's office functions in such a way that if a document reaches to a lower level staff member who works for the same office, they're not going to send it up the chain? That they're going to hold it? Are you telling me there are people working in the Chief Solicitor's office that have no idea what to do with documents when they are served? Really? The claimant's failure to comply with the legal rules governing service on the Attorney General means the judgment entered against the defendant in default of defense is irregular, wrongly entered, and must be set aside. A legal source with extensive experience in filing and litigating lawsuits against the state and who had sight of the application questioned Ramkisoon's suggestion on the service of the case. Now, I'm wondering if their legal source here is the former Attorney General, Mr. Ram Logan himself, because they said someone who has extensive experience in filing and litigating lawsuits against the state. Mr. Ram Logan will fit that bill perfectly, and someone who had sight of the application, and Mr. Ram Logan will fit that bill perfectly too. He pointed out that when they and their staff serve court documents on the ministry, the documents, are usually served on the ministry's legal staff who are contacted by its security officers. He claimed that senior state attorneys such as Moore, who may not be officially designated, would normally receive the documents and transfer them to the appropriate department or official. We do not get to pick who comes downstairs to receive the documents, the source said. That's kind of what I figured. So you go to this legal office, you speak to the security, tell them, well, we have this legal document to serve. They make an announcement upstairs, someone comes downstairs, and whoever comes downstairs, you give them the document. Are you telling me now that the state solicitor's office could send down the wrong person and you give this person, and now the state solicitor has an excuse? They could turn around now and say, well, we didn't get it served the right way, so... But you don't have a choice to select who picks it up. You spoke to the security, they selected who comes downstairs, but now they're saying the person that they sent downstairs to collect the documents, that was the wrong person. So now you wrongly filed the document. So how do you rightly file those documents against the state? Are you saying that now one must search and find? Well, first you must find who these senior state legal counsels are, and you must find them at their homes or something, and make sure you serve them personally? Is that what we're supposed to do here? Or is this just trying to find an excuse for what might really be incompetence? State judge wrong to grant default judgment in 8-minute hearing in the application. Ramkissoon also claimed that Justice Charles should not have granted the default judgment application in the 8-minute hearing before her, stating that determining such an application is not a routine administrative matter. Ramkissoon said the learned judge did not engage in any exercise of judicial discretion and did not properly evaluate the material placed before. I understand all these arguments, but these arguments are kind of made in a hindsight after they already made some of these errors. The thing is, the main crux of the matter here being the document that was filed. I don't buy that excuse. I don't get how that excuse could be reasonable, that it was given to the wrong person, although it was given to someone inside of the state solicitor general's office. But you're saying, no, that's the wrong person, although you sent the person to collect it. That seems like a you problem. If it was given to the wrong person, that seems like a you problem. That seems like the state solicitor general's office needs to tweak how they handle collecting served documents. That's what it sounds like to me. That doesn't sound like a problem that you could put on the claimant in that case, on the opposing legal team. That's not on them. That sounds like a you problem. And the you problems with our state litigation doesn't just end there. When you dig into this, it's problem after problem after problem. And you're seeing, just as I said at the beginning, what the officer was talking about, that, okay, yes, the police do their jobs sometimes. Sometimes they're doing their jobs properly. But then when they hand the baton, the proverbial baton, onto the next leg of the judicial race, they drop the ball, they drop the baton. Tobago pair freed of sexual offences charges over delay by DPP's office. Police. After almost a decade, a Tobago fireman and his former girlfriend were freed on Wednesday of 7 sexual offences charges owing to the protracted delay by the Office of the Director of Public Prosecutions and the police in prosecuting inquiry. In a ruling, Senior Magistrate Rajendra Rambachan upheld an application by lawyers for the two to have the matter discharged. Attorney Martin George argued it was unfair and unjust to continue the case because of the prosecution's failure to progress it. Rambachan agreed. The couple were charged on November 6, 2014. So long ago, with acts of grievous sexual assault against a then schoolgirl and track star in Mason Hall, Tobago, between August 31st and August 1st, 2014. George gave the court a timeline to support his contention that the prosecution was tardy and at fault. It showed the matter was fixed for trial several times, spanning August 2015 to July 2021, but was repeatedly adjourned, leaving his clients in abeyance. Abeyance is basically waiting. They're still waiting. And that's the reality in so many cases in our court system. They're waiting so long that the lawyer could plausibly make an argument that this isn't justice anymore. You haven't found my clients guilty of anything, so how could you have them under this specter of facing these charges, but you aren't bringing the charges? Is it just going to be that when charges arise against someone, it's going to be against them for the rest of their natural life? That's the reality we live with in Trinidad and Tobago. No, that's not justice. So I think the judge may be right in this case, senior magistrate may be right in this case to throw it out. But then think about the justice for the track star, for the teenage school girl who was grievously assaulted back in 2014 over the course of multiple months, August to October. Where's her justice? Does she get justice out of this? Okay, it might be justice for the accused because they haven't been found guilty of anything, but we don't even know if really and truly they were the ones who victimized the young schoolgirl, because apparently, according to the investigation, someone was victimized. The little schoolgirl was indeed victimized. Who did it? Who will face the consequences for this? And that's not necessarily on the police. That's not necessarily on the police because the people were already charged. They were already before the courts. The delay here is majority from the Director of Public Prosecutions. Listen to this. Permanent Secretary, abusers at children's homes have left or died. When we're talking about getting justice in this system, in our legal system, in our judicial system, talking about finding justice for people, the young lady in Tobago there, who was grievously assaulted, the accused gets to walk free because of our judicial system. Not because they were found innocent, not because they didn't do it, but because of flaws in our judicial system. And here, we're having a minister in the office of the Prime Minister. All staff members identified in the Judith Jones report on rampant abuse in state-assisted children's homes have either left the job or have died, said Vijay Ganga Prasad, Permanent Secretary in the office of the Prime Minister, on Monday. He spoke at a virtual briefing held by Ayanna Webster Roy, Minister in the OPM responsible for Gender and Children's Affairs. She also announced a delay in the proclamation of the law to allow unlicensed homes more time to become compliant. Ganga Prasad said, every single case, from what I was told, of matters being mentioned in those reports were committed by people who would have left the organization for one reason or the other, or in some cases would have died. And here's the thing. That's not justice. This is how our system works. A report was done. This report was done a while ago. It did investigations carrying back to decades of abuse, grievous abuse of the worst kind in children's homes against innocent children who are so vulnerable because they are orphans, many of them. They are in vulnerable positions already, and adults are abusing them. These adults, although many of them were named, although their crimes were highlighted, although there were witnesses willing to testify against them, the justice system just shrugged, and all of the guilty people inside here got to go free. Listen, the fact that they aren't working there anymore or they have died isn't justice. That doesn't say anything positive in Trinidad's light. That doesn't show a positive light on Trinidad. That says that people can abuse children in this country and live out their full, normal, natural lives without any consequence. The only consequence they face might be their conscience and God, and that's between them and God. That has nothing to do with the state. The state sees no justice from this. Is that how our system is supposed to run? And if you have things like that continuously being seen inside of our system, how do you expect people to act? Do you think people would act more along following laws, or do you think people would start to notice that, okay, these laws aren't here to really protect me, I kind of have to figure out ways to protect myself and see about my own self? You see, the idea of the judicial system is you have the overarching law and legal framework so that people don't think they have to take matters into their own hands. The family members of this track star in Tobago who was reportedly assaulted, they don't have to go and seek out justice on their own and find out those abusers and do something to them, because we promised them that we have police and a legal framework that is going to go out there and get justice on their behalf. But if they do not get justice on their behalf, what do we expect to happen? Remove convicted killer from death row, orders judge. A death row inmate has been successful in his plea to the High Court to remove him from the condemned cells so he can be resentenced. And regularly, you find people in Trinidad and Tobago, when you're talking about how do we solve crime, bring back hanging hang them high, hang them in Woodford Square, hang them in the promenade, kill them in the open, and that's what's going to bring the solution. But no. Because hanging is still in our law books. The problem is that our legal system is such a failure that they aren't capable of getting it done. I disagree with hanging, just by the way. I disagree with capital punishment because I do not believe a political framework, a political legislative framework, legal framework should be given the authority to capture someone and then kill them when you have captured them. That seems a bit strange to me. But either way, even if you think this is going to work, even if you think this is going to work, the legal framework, the way it is set up, doesn't even allow for the hanging. Now, current just went just by the way. The electricity went. We'll see how the recording goes without the artificial light. We just pulled the window. In a ruling on application on Monday, Justice Frank C. Prasad ordered the sentence of death imposed on Ronald Bisnat on March 27, 2014 be vacated. While C. Prasad refused to do the resentencing himself, he ordered that the Registrar of the Supreme Court should arrange for it to be done by a judge sitting in the criminal division. He also granted the declarations Bisnat sought that any attempt to carry out the death sentence would constitute a contravention of his rights, and his continued detention in the condemned cells would also be a breach. C. Prasad is expected to visit death row at the Port of Spain prison on Frederick Street on April 20th to inspect the cells. Bisnat of Crown Trace Enterprise was sentenced to hang in 2014 for the murder of 13-year-old Parmanand Boy Prasad, whose body was discovered in a partially built Shogunas house in 2006. So, the crime happened in 2006. He was sentenced in 2014. And in 2023, it still isn't carried out. So now the sentence has to be vacated, and he has to be resentenced. Prasad, a student of the Shogunas Junior Secondary School, was murdered on October 29, 2006. His body was found in the bathroom of a house at Crown Trace Enterprise. Police said he had been beaten and his throat slit, and he had possibly been sexually assaulted. At the time, they described it as one of the most gruesome murders they had come across. Bisnat was found hiding in some bushes close to where Prasad's body was found. In his application for his removal from death row, Bisnat's attorneys Jalaramdeen Wayne Sturge and Dayadai Harry Paul submitted that the client was being incarcerated on death row in excess of the 5-year limit set out in the Jamaican death penalty case of Pratt and Morgan. So you see, the reality is, if you're existing under this kind of British-style legal system, there's precedent where if you have someone on death row for over 5 years and it reaches to the Privy Council, they will not allow them to be hung because it's seen as a contravention of their human rights. You can't have someone tortured for 5 years. It's seen as being on death row is torture. So you're torturing me for 5 years and then still going to kill me. No, you're double punishing me there. The torture of death row for 5 years is punishment enough. That's kind of the legal idea there. So if you have them there for over 5 years, you can't do anything. And we did. So if you're talking about the legal system, the solution is hang them. Well, our legal system is too flawed to even do that. And the thing is, this isn't only a negative thing for the obvious criminals, the people who obviously may have done the crime and they may be able to escape. The flawed legal system can allow people who may be innocent in some cases and trapped up inside of the system to be punished unfairly, or the punishment inside of the legal system is now unfair in terms of how it's carried out. Let's hear what I'm saying. Fisherman jailed for ganja haul earns freedom. A judge has ordered that a fisherman from Central who was caught off the coast of Chaguanas with 50 kilos of marijuana in 2014 be released from prison. High Court Judge Nalini Singh recently ordered Baiju Harinarayan's release after ruling that he had already served his 6-year sentence for marijuana trafficking whilst on remand awaiting trial. Harinarayan of Sanford Street, Cova, agreed to plead guilty to the charge after he requested a maximum sentence indication from Justice Singh, who advised him on the potential sentence he would face if he admitted committing the crime. Harinarayan was arrested on May 18, 2014. According to the details of the case, the anti-Coast Guard officers who were on patrol off the coast of Chaguanas responded to a report of a suspicious vessel in the first Bocas near Shakashakari. The officers attempted to stop the pirogue and he tried to escape, and they found the marijuana on his ship. Now, the thing is, that happened in 2014. 9 years down the road, basically, he has not been found guilty yet. Bear in mind, our legal system is supposed to function on innocent until proven guilty. So the way our legal system is supposed to see and identify this man is as an innocent man. Mr. Harry Narayan, according to our legal system, is supposed to be an innocent man, but he has been on remand for this time. For all of this time, he has still been on remand. Now, if you are Mr. Harry Narayan here, and you are faced with the option, if I plead guilty, if I say I did it, then what's going to happen? Well, the years that you were on remand waiting to be found guilty would be counted as years served and you would be freed. Well, obviously, I'll say I'd do it. I've done it. And the thing is, think about this from a case where maybe Mr. Harry Narayan was innocent. I don't know. I don't know the details of this case. Bear in mind, the statement about what happened comes from the Coast Guard. Who knows the exact details of this case? We weren't there that night back in 2014. But let's say he was innocent. Would you be tempted to wait in remand until your case is called so that you can argue your innocence? Yes, I am innocent and I will argue it. Or would you just say, you know what? I did it. Already sat in jail for 8 years. I'll say I did it and I'm free now. Whatever. What do you think is going to be the pressure? Where do you think the pressure is going to lean on someone? And what does that cause for innocent people trapped inside of the legal system? As it were, the whole process of the legal system, of the judicial system, is to make sure that innocent people don't receive punishment that is due to guilty people. The prisons and punishment is for guilty people. The reason when you charge someone, you don't just throw them in prison and they go through this whole legal process is because we want to make sure that no innocent people end up in prison. Can we say that's what we're doing now? Can we say our judicial system is set up in such a way to make sure that doesn't happen, that the guilty spend their due time in prison and are not freed before time, and that the innocent do not spend their time in prison? Can we say our legal system is set up in a way to bring across that result? I'll say no. But that's my view. Tell me what your view is. That's all I have for now. I hope you're educated, informed, or entertained, and I will see you in the next video.